Get ready for the dictation. Start. Having heard the learned counsels for the parties, we will have to consider the negligence from the perspective of the law laid down. The term negligence means failure to exercise care towards others, which a reasonable and prudent person would in a circumstance, or taking action which such a reasonable person would not. Negligence can be both intentional or accidental, which is normally accidental. More particularly, it connotes reckless driving, and the injured must always prove that the either side is negligent. If the injury, rather death, is caused by something owned or controlled by the negligent party, then he is directly liable. Otherwise, the principle of res ipsa loquitur, meaning thereby the things speak for itself, would apply. The principle of negligence has been discussed time and again. A person who either contributes or is author of the accident would be liable for his contribution to the accident having taken place, and not otherwise. The division bench of this court in first appeal from order number 1818 of 2012, Bajaj Allianz General Insurance Company Limited versus Srimati Renu Singh and others, decided on 19/7/2016, has held as under. Negligence means failure to exercise required degree of care and caution expected of a prudent driver. Negligence is the omission to do something which a reasonable man, guided upon the considerations which ordinarily regulate conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do. Negligence is not always a question of direct evidence. It is an inference to be drawn from proved facts. Negligence is not an absolute term but is a relative one. It is rather a comparative term. What may be negligence in one case may not be so in another. Where there is no duty to exercise care, negligence in the popular sense has no legal consequence. Where there is a duty to exercise care, reasonable care must be taken to avoid acts or omissions which would be reasonably foreseen likely to cause physical injury to person. The degree of care required, of course, depends upon facts in each case. On these broad principles, the negligence of drivers is required to be assessed. It would be seen that burden of proof for contributory negligence on the part of deceased has to be discharged by the opponents. It is the duty of driver of the offending vehicle to explain the accident. It is well settled law that at intersection where two roads cross each other, it is the duty of a fast moving vehicle to slow down, and if driver did not slow down at intersection but continued to proceed at a high speed without carrying to notice that another vehicle was crossing, then the conduct of driver necessarily leads to care. It is a case of composite negligence where injuries have been caused to the claimants by combined wrongful act of joint tortfeasors. In a case of accident caused by negligence of joint tortfeasors, all the persons who aid or counsel or direct or join in committal of a wrongful act are liable. In such case, the liability is always joint and several. The extent of negligence of joint tortfeasors in such a case is immaterial for satisfaction of the claim of the plaintiff oblique claimant and need not be determined by the court. However, in case all the joint tortfeasors are before the court, it may determine the extent of their liability for the purpose of adjusting inter se equities between them at appropriate stage. The liability of each and every joint tortfeasor vis-a-vis to plaintiff oblique claimant cannot be bifurcated, as it is joint and several liability. In the case of composite negligence, apportionment of compensation between tortfeasors for making payment to the plaintiff is not permissible, as the plaintiff oblique claimant has the right to recover the entire amount from the easiest target's oblique solvent defendant. Stop.